Right now, sitting in a filing cabinet or a desk drawer somewhere in your home, there is very likely a piece of paper that has more control over who inherits your house than your actual will does. You've probably never looked at it in years. You may not even remember signing it. And if it says the wrong name on it, your will, no matter how carefully you wrote it, no matter how recently you updated it, no matter what your actual wishes are, will not be able to overrule it. Your house, the single largest asset most retirees own, could legally end up in the hands of someone you never intended, someone your family has never met, someone who has no connection to you whatsoever. And the terrifying part is that this happens to real families, quietly, legally, and completely preventably, every single year. My name is Finn, and this is Finn Retires, the channel that exists to make sure the things you've spent a lifetime building actually end up exactly where you want them to. If this is your first time here, please hit that subscribe button right now before we go any further. Every single week on this channel, we cover the rules, the mistakes, and the overlooked details that put retirees' financial security at risk. And today's topic touches something even more personal than money. It touches the home you raised your family in, the place that likely represents the largest single asset in your entire estate. So subscribe, stay with me, and let's make sure your house actually goes exactly where you intend it to. Let me start with a fact that I think genuinely surprises most people. According to recent estate planning research, only about 24% of Americans currently have a will. Read that number again. Not 70%, not 50%, 24%. And it gets more concerning from there. Over half of all Americans have no estate planning documents whatsoever, meaning no will, no trust, no power of attorney, nothing. If you fall into that majority and you pass away without a will, your home does not go wherever you might have casually mentioned to a family member over the years. It goes exactly where your state's intestacy law says it goes, following a rigid, predetermined formula that has nothing to do with your actual relationships, your actual wishes, or the reality of who was actually there for you in your final years. Every state has its own specific formula, and depending on your family structure, results can be genuinely unexpected, sometimes splitting ownership between people who have never even met each other. But here's what I really want you to understand today, because this catches even retirees who have done everything right completely off guard. Having a will does not automatically mean your will controls who inherits your house. I want to say that again because it runs counter to what most people assume. Certain assets are governed entirely by their own separate legal designation, completely independent of whatever your will says, and your house can absolutely fall into this category depending on how it's titled. Retirement accounts, life insurance policies, and critically for today's topic, property with a transfer on death deed or property held in joint tenancy, all pass directly to whoever is specifically named on that particular document. Not whoever is named in your will. Whoever is named on that specific piece of paper, regardless of when it was signed, regardless of whether it reflects your current relationships, and regardless of what your most recent will says. Here is exactly how this becomes a real problem in real families. Think about a transfer on death deed, sometimes called a beneficiary deed, which many retirees use specifically to help their house avoid the probate process. This is a legitimate, useful legal tool, but it only works correctly if it's kept up to date. Imagine a retiree who set up a transfer on death deed on their house 15 years ago, naming their spouse at the time as the beneficiary. That marriage later ended in divorce, the retiree remarried, and years later updated their will to reflect their current spouse. But the transfer on death deed on the house was never updated. When that retiree passes away, the house does not go to the current spouse named in the will. It goes to the ex-spouse named on the deed because that deed operates entirely independently of the will, and the law does not assume you meant to update it just because you updated something else. The same exact problem applies to jointly owned property. If your house is titled in joint tenancy with right of survivorship, a common arrangement for retirees who added an adult child to the title years ago for convenience, that property automatically passes to the surviving joint owner the moment you die, completely outside of probate, completely independent of your will. If you added one specific adult child to your house title decades ago, and your will says the house should be divided equally among all your children, the title designation wins. The house belongs entirely to the one child named on the title, regardless of what your will says, and your other children have no automatic legal claim to it whatsoever. Now, let's talk about what happens to a house that does pass through your will, because even that path comes with real costs and delays. This process is called probate, and it is the court-supervised process of validating a will, paying off debts, and formally distributing what remains to the named heirs. Probate is neither fast nor inexpensive. Depending on your state and the complexity of your estate, probate can take anywhere from 6 months to 2 full years to resolve completely. During that window, your house is often tied up, meaning your family cannot simply sell it, refinance it, or fully take possession until the court process concludes. And probate is not free. Legal and administrative fees typically consume somewhere between 3 and 10% of your total estate's value, depending on your state and how straightforward or contested the process is. For a retiree whose home represents the bulk of their estate, that percentage is a genuinely significant amount quietly leaving the family. There is one more threat to your family home that deserves specific attention because it's almost never discussed openly. This is called Medicaid estate recovery, and it specifically applies to any retiree who received Medicaid-funded long-term care at age 55 or older. Under a federal law called the Omnibus Budget Reconciliation Act, every state is legally required to attempt to recover the cost of that long-term care from the deceased recipient's estate after they pass away. Here's the detail that catches families completely off guard. While you're alive, your home is generally exempt from being counted against you for Medicaid eligibility, but that exemption only applies while you're alive. The moment you pass away, your state can file a claim directly against your home to recover what was spent on your care. Depending on whether your specific state uses what's called expanded estate recovery, that claim can potentially reach your home even if it passed outside of probate, through joint ownership, or through a living trust, depending on exactly how that trust or ownership arrangement was structured. I want to be genuinely clear about something because I don't want this video to leave you feeling like there's nothing you can do. There absolutely is. Every one of these outcomes can be prevented or significantly reduced with the right legal tools, used correctly and kept up to date. A properly funded revocable living trust can allow your home to pass to exactly who you intend, generally avoiding probate entirely, and may offer meaningful protection against certain estate recovery claims. A correctly executed and regularly updated transfer on death deed can accomplish similar goals for a lower upfront cost. Let me walk you through a realistic example. Consider a retiree named Vernon, 76 years old, living in Oregon, a widower who had been remarried for 12 years to his second wife, Carol. Decades earlier, during his first marriage, Vernon had set up a transfer on death deed on the family home, naming his first wife as the beneficiary, a completely reasonable decision at the time. After his first marriage ended and he remarried Carol, Vernon updated his will multiple times, each time clearly naming Carol as the intended recipient of the house. He genuinely believed his estate was in order. He had a current will, he had discussed his wishes openly with his children, and he felt confident everything would proceed exactly as he intended. When Vernon passed away, his family discovered, during an already difficult time, that the transfer on death deed from decades earlier had never actually been updated. Because that document operates independently of a will, it legally controlled who inherited the house, regardless of what Vernon's current will said. Carol, who had lived in that home with Vernon for 12 years, had no automatic legal claim to it whatsoever under that outdated deed. The situation was eventually resolved, but only after months of legal proceedings, real financial cost, and family stress that Vernon had specifically tried to avoid.